Brian with Attorneys of Idaho. We're here to talk to you about the process of a personal injury lawsuit. After we're kind of rolling in discovery and we've had depositions, then generally what'll happen is something called mediation. Usually for that, we go see a guy named Chris down off of River Street downtown, and he'll come and talk to us and help try and see if we can come to some sort of agreement with the insurance company on how much money your case is worth. That works pretty often. Chris does a great job. And generally what we'll do is we'll come again with the story that we have to tell about how this has impacted your life and the lives of your loved ones. He'll take that story directly to the attorney for the insurance company as well as the adjuster and help them try to understand that this is going to get worse for them if we do proceed to trial. So mediation is really a way of getting another attorney involved to help us go back and forth, try and come up with a compromise or settlement a little bit later in the game, usually a few months before trial. If we're able to come up with some sort of settlement agreement at the mediation or at any other time in the proceedings, then generally what will happen is we'll sign a release, and that release will be something along the lines of, you agree to drop your case against the other party as long as they pay you a certain amount of money that you've agreed on. But if we can't get a release together and we can't get a settlement reached, then we move into trial preparation. The trial preparation at the back end is really about me putting together really compelling stories and whittling everything down to a very concise statement about who you are, how this impacted you, making sure we have a compelling doctor that's going to come in and explain your injuries, making sure that you're ready to testify, because you are going to have to tell your story on the stand, and then getting a couple people from your family together who are willing to come in and explain how much of an impact this has had on them and on you. If we proceed to jury trial, generally those are 3 to 5 days here in Boise or Caldwell in the Treasure Valley, and can be a little bit longer or shorter depending on the complexity of the car case. If we proceed to trial, the very first step is something called voir dire, and that's French for to seek the truth. What that means is we'll sit down with a big group of people from the community, and we'll try and figure out exactly who the worst people for your case would be. And you'd think you want to try and pick the best ones, but the trick with voir dire is you only get to get rid of people. You don't get to save anyone. So we'll ask questions to try and figure out who doesn't like you, who doesn't believe your story, who doesn't think that pain and suffering is real, and who thinks that you should only be compensated for the medical records and the medical bills. Once we figure out who the bad fits are in your case, we'll get rid of all those people. We'll end up with a fair jury who will decide exactly whether you're at fault or the other party is, then how much money to give you. Once we get done with voir dire, we move into the opening statements. The opening statements is our chance to start to tell your story. We don't get to argue at all. We simply get to explain exactly what happened on that day when you got into the car crash, and then how that has impacted your life and the lives of your loved ones every day since. That's my chance to stand up and tell your story for you. So it's really important that we have an opportunity to kind of build that through the entire case. Once we get done with opening, we go into direct examination. Direct examination is our way of presenting our case. So anybody that we can find that we decide is a good fit, we'll have them come in and actually testify on your behalf. They'll stand, they'll take an oath, they'll sit right next to the judge, and I'll ask them a bunch of questions to help them tell your story for you. Eventually, it'll be your turn, and you'll get to tell your story as well. The trick with that is making sure that you're talking to the jury and you're explaining truthfully the impact this has had on your life. Now, the defense attorney will always have opportunities to cross-examine you, and cross-examination is kind of a way of trying to badger you into changing your story, or admitting you were lying about something, or for them to try and highlight parts of your treatment that they don't like or don't agree with. But the issue with that is, as long as we're telling the truth, which we will make sure we are when we get there, as long as we're telling your story truthfully, there's nothing they can do to harm us. Once we get done with what we call our case in chief, that means our opening and our witnesses, then it's defense's turn. Sometimes they'll have their own experts that can come in and try and say that your issue with your shoulder that you had a little bit of pain in before was actually needing surgery before the car accident case. Now, we'll always have our own experts ready beforehand who will testify and explain exactly how those injuries are related to your car accident and explain really the mechanism that caused that injury and what surgery was needed, how much that surgery was costing, and how painful that injury was for you. After they get done presenting their witnesses, then we go into closing arguments. Closing arguments is my opportunity to kind of draw a string together through all of it, to explain what your story is through your witnesses that came in and testified on your behalf, and tell your story of recovery. Because we always push for a story of recovery rather than one of pain. So we tell that story at the end and we relate it to the car accident. We help them understand that impact they did have, but the fact that you made it through. Once we get done with that closing argument, we'll always have a number ready. And that's something that you and I will have talked through to figure out exactly how much money we want to ask for. Now, Idaho has an economic cap. What that means is we can ask for all of your medical bills, but we can only ask for a certain amount of money when it comes to pain and suffering. And in Idaho, that cap is $490,000. That changes every year based on inflation. Once we're done with closing, the other side gets to give their closing as well. We'll try and talk about how these injuries weren't that bad or they weren't related, or you really didn't hurt that much, and they'll try and come up with a smaller number for the jury. The judge will then tell the jury that it's their job to be fair. It's their job to apply the law to the facts and to the testimony and evidence they heard. And the judge will send a jury out to the jury room to make a determination of, one, who was at fault for the car accident, and two, if the defendant was at fault, the other driver, exactly how much money they should pay you in compensation. After the trial's over, there may be some post-trial motions. In Idaho, there's a thing called contributory negligence. What that means is the jury might find that you're partially at fault for this. And let's say they find that the other driver was 80% at fault and you're 20% at fault, and they award you $100,000 in damages. What that means is they're going to reduce the amount of damages you get by that 20%. So that means that you'd end up with $80,000. Now, the second way that can get reduced is, let's say you have really good health insurance. You have $40,000 in medical bills, and your health insurance company had a good relationship with the medical provider, right? You ended up with $40,000 in medical bills, but your insurance only paid $10,000 of it. In a case like that, if the jury awards you the full $40,000 in medical bills, the judge will look at the amount that was paid by health insurance and will reduce that $40,000 down. Those are the two main ways that the case may get reduced. The other way is the defense attorney may file some post-trial motions to try and tell the judge they think the jury gave you way too much money. Let's say we have a pretty small case where you don't have a concussion, you just had to see the chiropractor a few times, and the jury still gives you $490,000 in pain and suffering damages. In a case like that, the defense attorney may file a motion to the judge and say, "Judge, this is way too much money. Please don't let them actually take this much from my insured." At that point, generally the judge will have to make a determination whether they think the jury gave a fair award or not. And I'll always be there to continue to advocate for the amount that we won from the jury. The defense attorney can also move forward with an appeal. So if they don't like the amount that was awarded, or they don't like some of the ways the judge ruled on the case, they can appeal the case to the Idaho Supreme Court. And the Idaho Supreme Court will take the case and decide whether the trial was fair or not. Oftentimes, that appeal will come with a post-judgment settlement offer. What that means is, let's say we win $500,000 for a relatively small case that only involved a few chiropractor visits. The insurance company may say, look, we're going to appeal this case, and an appeal generally takes 1 to 2 years, and we're going to fight the entire time, or we'll offer you $300,000 today to settle the case. We'll see it pretty commonly in a case like that. They will make those types of post-judgment offers in an attempt to see if they can leverage you to taking a little bit less than the jury awarded you versus continuing the case on an appeal for the next 1.5 to 2 years. Last step is always, how do we get you your money? How do we get it from the insurance company? Generally, if it's a case where we're not going to trial, they're making a settlement, they're always just going to pay it to you up front. That's something where they'll send the money to us, we'll put it in our trust account, we'll make sure that we have all of your medical bills collected and paid for. We'll negotiate with your health insurance to make sure that we take care of all your health insurance bills as well. And then we'll send you a check, or we'll overnight it, or we'll come drop it off at your house if you want us to. Make sure we get you that money as fast as we possibly can. However, we have a few cases where people are hit by a driver that's uninsured. Sometimes in a case like that, it can be really difficult to collect that payment. We can go through the collections and garnish that person's wages or put a lien on any real estate they have. Again, these are the common stages that you'll see in a car accident case, whether it's pre-litigation, demand, or litigation. While every case is a little bit different, this can give you kind of a rubric in understanding what could happen if you hire us on to help you with your car accident case. If you have any questions, or you want us to pick up the case at any of these stages, give me a call, Attorneys of Idaho, at 208-314-8888. Thank you for listening.